Hey guys, Coach Cersei here. Welcome to the Judicial Branch. So where we are now, this is Unit 3. You guys have already looked at the creation of the Constitution. You've already looked at the founding of our government, the type of government that we have, all the things that make it up. You guys have also done some assignments that have introduced you to the various components of the Constitution. Which articles created what branches of government. We looked at, Article 1 creating the legislative branch, Article 2 with the executive branch, Article 3 we had the judicial branch. And we've looked at those and started to understand a little bit better the various powers and those things that are granted within the Constitution. And so now we want to start with the individual branches of the government. And we're going to start with the judicial branch. Because one of the things that you guys looked at in the web quest was some of the civil rights you looked through, and one of your creatives that you're working with, as a matter of fact, you're probably working with it right now, is that Bill of Rights creative. And so again, we're looking at the judicial branch. It is, essentially the adjudication part of our government. Remember, there are three branches in the separations of power, right? You have the executive branch, legislative branch, and judicial branch. Executive branch, right, that executes the laws which are written by the legislative branch, and then the determination of whether these laws are constitutional is responsibility of the judicial branch. And so each of those branches have its own distinct powers that keeps the other branches from becoming too powerful. That is what we call the checks and balances. And I think we talked about those in U.S. history, but certainly going to talk about it here in government. But let's get into the judicial branch. Since when we talk about the judicial branch, primarily we talk about the Supreme Court of the United States. But we also need to consider the entire, not only the federal court system, but also the state court system. Now, the Supreme Court was created by the Constitution. Now, it is the only court that is actually created by the Constitution. The other courts are created by Congress. Now, Congress was given this power to create the court system, and that was done so by the Constitution. The power is given to it in Article 1 of the Constitution. So again, if you ever hear, what was the only court that was created by the Constitution itself, that would be the Supreme Court of the United States. The other courts were created by Congress, okay, through their legislative power granted by the Constitution. Now, the federal court system is divided into districts called circuits. There are 11 circuits throughout the United States. As you see here, we are here in the state of Georgia. That would put us in the 11th circuit of the federal court system. Now, there are within these circuits, we have 13 appellate courts. We call these the U.S. Court of Appeals. There are 13 appellate courts, and there are 94 district and trial courts. So there's, our federal court system is quite large, and they are responsible to oversee and adjudicate federal cases. Now, there are two actual court systems in the United States. We have the federal system and we have the state system. The federal system, obviously, they handle disputes regarding laws that applies to the United States. These are federal laws. If you're caught counterfeiting money, right, printing money and using that, or trying to distribute fake, that is a federal offense. Now, states handle disputes regarding laws that apply to a state or a state constitution. And so you'll see some of these different types. Civil rights, bankruptcy laws, copyright, and immigration laws. Those are all federal laws. Civil rights deals with those rights that are protected by the Constitution that the government protects. Those are federal laws. Bankruptcy, many of your creditors, when we get and you owe money or we get loans, are not done in a specific state, but they're done between organizations or companies or facilities outside of the states. And copyrights are those, remember, those ownerships of anything that we create, your song, your artwork, your book. Those are copyrights. Those are ownerships. Well, that's not just in one particular state or municipality. That is at the federal level. Also, immigration, certainly immigration into the United States, obviously, if those are federal laws. So those are overseen by the federal court system. The state court system look at criminals. While there are federal courts do adjudicate and try criminal cases that involve federal laws, for the most part, criminal cases are adjudicated and done at the state level. Divorce, When you are married, you are granted a certificate and a license by the state. And so, of course, the dissolution of that marriage would happen at the state level as well. Also, real estate. Land resides in a state, and so any type of real estate transaction, when you buy a house or buy land, that land is in a state, and that will be handled at that state level. Also, wills. Wills are how those, when someone passes away, how they would like their belongings, their assets distributed. That is done by the laws and according to the laws of particular states. So those are some, again, the different types of cases, and of course the two different types of court systems. Now, we have two different types of cases that exist in both court systems: criminal cases and civil cases. Criminal cases relate to violation of law or crime. Okay, if you violate a law on the books, that would be considered a criminal case. Now, civil cases relate to the rights of citizens. If I am renting an apartment from you and I choose not to pay you rent, well, that would be a civil case. That would be one case, and you would bring that case against me as an individual. Now, of course, there are cases that have a criminal and civil aspect to it. If you break a law, let's say that you are speeding and you crash into another car, and God forbid someone is hurt, seriously injured in that, there might be a criminal case could be driving under the influence. I pray that none of you ever do that. And that is actually breaking a law. And so there would be a criminal aspect to that. But then if anyone is injured in that accident, there could be a civil case brought forth. And so, but those are the two types of cases. And as we look back at those federal and those cases, you will see some of the different types. Now here, let's look at quickly some courtroom terms and overall types of processes. Evidence. Now, if we're in a classroom, we talk about the different types of evidence, and we would say maybe an eyewitness account, pictures, film. Now with DNA, if we watch any of our those court, the shows, the police shows and NCIS and all that, it's all about DNA, and it's all about computer, it's all about phone calls and things. And certainly with our cell phones now, instant access to pictures and video and recordings, things. But those are evidence, and evidence is used to either try to prove innocence or guilt within a case. Now, there are two types of trials that happen within our court system. One is a jury trial, and that's where a jury, a number of people, actually listen to the evidence that is presented by the plaintiff and then also presented by the defendant. Those attorneys, those two sides. The plaintiff brings the charges and actually initiates the case, and the defendant is the person that's being accused of a particular crime or issue. And then the jury actually listens to the evidence presented, and then they render a verdict. The other type is a bench trial, and this is where the actual verdict, as we see here, that's the decision, guilt or innocence, is determined by a judge. And so, again, jury case is given by a group of people that have to have unanimous. They have to all agree, and they have to all agree on the verdict. And then that verdict is presented. But then the bench trial, the verdict is determined by a judge. Now here's a question. What if you don't like the verdict that is given and presented and come up by the jury or the bench trial? Well, of course, you appeal it. And this is where we start what we call the appellate process. So the appellate courts, there are two levels of appellate courts. There's the Court of Appeals and then the Supreme Court. Now, there are state court of appeals and there are federal court of appeals. And the same thing here, there are state Supreme Courts and there are federal, the United States Supreme Court. That's where they have the two levels here. Now, the appellate process is pretty consistent for both. So here we go, a trial court, whether it be a state trial court or a federal trial court. They hear the case first, right? It's presented by the two sides, right? The plaintiff and the lawyer and the side for the plaintiff as well as the defendant. And so that evidence is presented, and then this trial court, whether it be a jury court or a bench trial, right, is presented and they come up with a verdict. Now, if that verdict is unacceptable, right? Then that is then sent to the Court of Appeals. You apply to have an appellate court hear it. Now, the Court of Appeals actually reviews the trial court decision for error. They don't retry the actual case. What they do is they look back at the case, look at how it was tried, how was the evidence presented, were there any errors made in the assessment of the evidence, or just in the overall how a verdict was reached. And then this decision, whatever the decision of the Court of Appeals, must be followed by all trial courts below it. Now, even if that particular decision of the Court of Appeals is not liked, then the application to be heard at a higher court. Now, most Court of Appeals cases are actually heard by a panel of 3 judges, and what that does is that allows for 3 different sets of eyes to look at the evidence and look at how the case was actually tried to determine whether there were any errors. But if that verdict by the Court of Appeals is not desirable, then it is applied, or you have the option to appeal to be heard at the Supreme Court. Now, the Supreme Court does something very similar. It reviews the appeals court decision for error. And so now, as you see, this kind of consistent type of stepstones or stepping process up. And so the Supreme Court looks at as well, looks for any errors, and then they decide. Now, the Supreme Court decision has to be followed by all lower courts. Now, so as we look at this is a question that always comes up. Does the Supreme Court have to hear all cases? The answer to that is no. They do not. The Supreme Court does not have to hear all cases. As a matter of fact, there are thousands and thousands of courts, certainly to the United States Supreme Court, but it only decides to hear a certain number of those. So let's get into that process. So as we talk about the Supreme Court of the United States, and we think about the judicial branch, this is always what comes to mind. So let's look at this and see how the Supreme Court is made up and really what kind of cases it listens to. Because often the cases heard are disputes as to whether a law violates the Constitution. Again, that is one of its powers in the separation of powers, right? The constitutionality of laws that are one written by Congress and then signed into law by the president. So that is that checks and balance that the Supreme Court or the judicial branch has over the executive branch and the legislative branch. But most of these cases that are heard at the Supreme Court deal with the issue related to civil rights. And we talk about that, those first 10 amendments constitute the Bill of Rights. And when you look at Supreme Court cases, so many of them have to do with the issues related to civil rights. Now here's, when we talk about the final say, the Supreme Court, they have the final say in any court decision, and they are the only, in other words, the Supreme Court is the only one that can actually reverse a Supreme Court decision. So if the Supreme Court renders a decision and then later on comes back and decides that based on other considerations, and they decide as a court to reverse that, they are the only ones. An appellate court can't reverse a Supreme Court decision, and certainly a trial court can't. So let's look at the makeup of the Supreme Court as it exists today in the year 2020. Chief Justice John Roberts is the Chief Justice, and the Associate Justices, Neil Gorsuch, Ruth Bader Ginsberg, Brett Kavanaugh, Samuel Alito, Elena Kagan, Sonia Sotomayor, Clarence Thomas, and Stephen Breyer. Those are the 9 Supreme Court justices that currently reside on the Supreme Court. So let's look at the selection process for just judicial selection for federal judges as a whole. There are no formal qualifications for federal judges. They all serve during what they call good behavior, which generally means for life. Certainly, this is a presidential or executive appointee that is confirmed by the Senate. But this whole thing, we look at this, generally means for life, and they serve for life. A lot of people ask why. Why is that? Well, this appointment during good behavior allows the judges to actually be free from the political pressure when deciding cases. So consider a case that is not necessarily popular to the citizenry. but is certainly one that falls within the constitutional boundaries of the Constitution itself, and the judge feels that they have to, because from the constitutionality, have to render such a decision. Well, if it's not very popular, if they were elected, then there would be a chance that they might not be reelected. And so having this to be able to have a lifetime appointment so they're not necessarily elected by the citizens frees them from the political pressures from deciding a case one way or the other. Now, one way that the judges can be removed from office through impeachment and conviction, and that has happened a few times, not very often. So let's look at the selection from lower courts. The president, even though it is a presidential selection or recommendation, and then it's certainly a Senate confirmation, the president doesn't do a whole lot with choosing some of the lower courts. And that's not 100% of the time, but for the most part, the president doesn't, because this is due to a large number of appointments. Usually the Department of Justice, the White House staff handles most of those. There is also a thing that we call senatorial courtesy. And that's really where it allows the senators from the president's party who represent the state, maybe where the vacancy is, to approve or disapprove nominees. And that gives them the opportunity then to be a part of that appointment process, where it doesn't necessarily keep the president bogged down with the overwhelming number of federal court appointments at the lower courts. But certainly when it comes to the Supreme Court, the president gives much more attention to that, because they're the high visibility and importance. These are significantly important appointments. Now, when making these appointments, presidents often consider, they don't always, but these are some considerations that the president may think of. Political or party affiliation. They could very well want to choose a judge from their political party. And a lot of this is based around their judicial philosophy or their ideology. They want to make sure that because of the president's ideology or their party ideology, that there's a level of congruency between how the judge feels from an ideological perspective and how might they rule, and the party's ideology. And we're going to talk about the two different types of judicial philosophy here shortly. Also, they may consider race, gender, religion, or the region of the country that they come from. While that is certainly not something that is overtly done, listen, to be honest in this, that could very well be a consideration. Also, their judicial experience. They want to make sure that they have experience as a judge or an attorney if you're going to appoint someone to the Supreme Court. And I would tell you, if they don't have any previous experience as a judge or attorney, there's a very slim chance that they would be appointed to the Supreme Court. Now, while this is not an overt type of consideration, there may be a litmus test that is considered. And a litmus test is something that considers how a judge would rule based on a particular issue. Could be abortion, could be religious freedom, could be a number of different things, and certainly depends on the political climate and how things are going in society at a certain time. How they rule on how a judge rules on a particular issue could very well be a consideration of whether or not that judge is considered for appointment or even gets confirmed. Also, acceptability. Hey, listen, bottom line, the Supreme Court justices have to go through a confirmation hearing, and sometimes they get incredibly heated. And so if this is a potential justice that has a very controversial background, or their rulings have been significantly controversial or whatever, or they're just, their profile, their social actions haven't been something that would be necessarily appealing, or could be something that may not necessarily be acceptable, that they may not necessarily get that nod. If there's somebody that has a hard time getting through a Senate confirmation, they may not necessarily be chosen. All right, so let's look at the Supreme Court at work. They actually start their session the first Monday in October, and they generally last through June or July of the following year, the next year, depending on the number of cases that they have to try or rule on. All right, so let's do a quick how the Supreme Court works and how it accepts a case to review. There are literally thousands of cases that are appealed to the Supreme Court every year, and only a few hundred are actually heard, sometimes even less. Most cases are denied because, one, the justices agree with a lower court decision and there's no reason to listen to it again or make any kind of judgment. Or the justices believe the case doesn't really involve a significant point of law. So, again, this is one of those that they only have a certain amount of time and they have a certain amount of space that they can look at and rule on cases. So they have to be selective. Also, cases that are accepted must meet the rule of 4. This is where 4 of the 9 justices must agree to hear the case. And so again, 4 of the 9 have to agree. And also, many of the cases accepted may be disposed of in brief orders. And this is where they return to the lower court for reconsideration because of a related case that might have been recently decided. Again, sometimes it takes a while for a case to make it there, and there are court decisions that happen throughout time, and that they may send back if a particular issue has been decided on in a case or related to it. The Supreme Court may send it back for reconsideration by a lower court. Also, cases presented at the Supreme Court may be presented through a writ of certiorari. This is an order by the court when petitioned directing a lower court to send up records for a case for a review, or just by certificate where the lower court asks Supreme Court about a rule of law or procedures in specific cases. That's how they would be presented to Supreme Court. Now, briefs and oral arguments. Once a case reaches Supreme Court, the lawyers for each party file what they call a written brief. This is a detailed statement of the facts of the case supporting a particular position by the presenting arguments based on relevant facts, citations from previous cases. This is also where they would quote previous cases, and they would use them as precedent. They would say, okay, this based on this particular ruling in this case, in this case, in this case is why we are presenting this to you. Now, also that they have oral arguments. So they would present a brief, and then the oral arguments would allow both sides to present their positions to the justices during a 30-minute period. So they would be able to present their case. The justices may interrupt the lawyers during this time. They could raise questions. They could challenge points of law, but they do not retry a case. In other words, the lawyers for the sides are presenting the evidence and also other cases related to that and other decisions. When writing the opinions, the Supreme Court decisions are explained in a written statement called an opinion. Now, if the justice is voting with the majority, or the majority, the Chief Justice actually selects who will write the opinion. In other words, the decision by the majority, the Supreme Court, the Chief Justice will select who writes that opinion. If voting for the minority, in other words, if it's a 5-4 decision, the 4 justices, the most senior associate justice of the majority selects who will write for the opinion. Now, there are 3 types of opinions. One is a majority opinion. This is where the opinion agreed upon by a majority of the justices. There's a concurring opinion. This is where written by a justice or justices who agree with the majority opinion, but not with the reasoning behind the decision. They may agree with, okay, yes, we are going to rule in this certain way, but I have a different perspective or a different opinion or interpretation as to why I believe the way I believe, that I am ruling the way that I rule. It may not necessarily be completely in line with the majority opinion. Then there's the dissenting opinion. This is written by justices who disagree with the majority opinion. Now, majority opinions become precedents. Now, these precedents become standards or guides to be followed in deciding similar cases in the future. I use the example Roe v. Wade on abortion. So, abortion cases that are brought before Supreme Court, the ruling in Roe v. Wade may be considered a precedent. Now, this leads us to, as we get into judicial philosophy, because when we look at these precedents that are set, this is where it gets into a little bit of gray area, because when we get into that separation of powers, when we talk about that, the checks and balances, it is the role of the legislative branch to actually write laws. It is the role of the executive branch to execute laws, and in the role of the judicial branch to interpret the constitutionality of laws. This, when we talk about these precedents, and oftentimes the precedents are used to then provide a level of either support or a level of trying to refute a particular law or the legality of a law, as opposed to allowing the law to actually be either rewritten or abolished. And so let's get into these two different types of judicial philosophy. One is judicial activism. The other is judicial restraint. So judicial activism is very similar to what I was talking about before. This is the judicial philosophy that believes that the court should play more of an active role in creating national policies and be a part of answering the questions of conflict in society. In other words, as opposed to having the legislative branch actually draft laws to address national policy or address conflict in society, and then to be written into law or signed into law by the president, and then determined the constitutionality by the judicial branch, many on the judicial activism side say that the judicial branch or the Supreme Court should actually, or even the federal court system, should play a role in influencing the legality of law. So in other words, as opposed to rewriting a law by the legislative branch, the court's decision becomes more law. And that's that part of creating those national policies as opposed to the overall legislative process to write laws. So that is kind of the background of judicial activism. Judicial restraint is the other side of that. The judicial restraint philosophy or judicial philosophy believes that the court should operate strictly within the limits of the Constitution and only answer questions if a clear violation of the Constitution is present. Those who believe in judicial restraint, judicial philosophy, believe that the policy making should be left up to the executive and legislative branches. In other words, the court decision should not become policy. It should be, the court decision should determine either legality or the constitutionality of a particular law, not to rewrite laws. So those are the two types of philosophy. And this, when you look at political ideology, you will see how these two types of judicial philosophy fit within those political ideologies. And again, this is one of those back and forths, and certainly has created a levels of contention across the political aisles in society and even federal court systems and across the board. And so this is where we get into our overall political ideologies and the back and forth between political philosophies. So that's the judicial branch kind of in a nutshell. There's certainly, we can go a whole lot deeper into many of the processes and how things happen, but I wanted to provide you a brief foundational, just overall general look at the judicial branch. Certainly, if you have any questions, email me, and you can go on and check out some more of the resources that we have. I look forward to seeing you in class. Have a great one.